The International Covenant on Civil and Political Rights guarantees that everyone is entitled to a name and a nationality. But how can a nationality or citizenship be defined? In law, we usually refer to two types of nationality attainment or citizenship acquisition. They are jus soli and jus sanguinis. Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll learn the differences between jus soli and jus sanguinis. I should start by saying that when we're dealing with the law of nationality, the terms nationality and citizenship are used interchangeably. I'll be using both terms as I go. Okay, we all have this right to a nationality, but how is a nationality defined? What are the rules that dictate what birth citizenship a person will have? In law, we have these two terms that encompass the whole of the ways in which a nationality can be acquired. They are jus soli and jus sanguini. Jus soli is Latin for right because of soil. In jus sanguini, Latin for the right because of blood. This literally means that when a country adopts the jus soli, the person who is born in that soil, in that land, within the bounds of that territory, in that country, that person becomes a national of that country. It doesn't matter where your parents are born. If when you were born, they were visiting a country or living there permanently, if that country adopts the jus soli rule, that means that since you were born in that country, you become a national of that country. There's a long list of countries that adopt this rule for citizenship. I can highlight here countries like Brazil, the United States of America, and Canada. Now, if a country has adopted the rule of jus sanguinis, then there's a limited birthright for those people who are born within the territory of that country. Differently from the jus soli, it does not matter where you were born, as long as you have a bloodline. Jus sanguinis says that the nationality is acquired by blood, and blood here means descent. It means that you come from a bloodline of nationals, of people who are citizens of a particular country. If your mother or your father is a citizen of a country that adopts the jus sanguinis rule, then that means that you will also be entitled to that citizenship because of your bloodline. Most of the countries outside North and South America are like that. Italy, Israel, the UK, South Africa, these are all countries that adopt the jus sanguinis rule. But this channel is called Aussie Law, so what's the rule in Australia? I will answer it very shortly because first, I think you should take the moment to like this video, subscribe to our channel and hit the bell icon. And now you can also join our community by becoming a member of Aussie Law. So, Australia has a mix of rules. In fact, most of the countries have a mix of jus soli and jus sanguinis.
Okay, Renato, that is really not helpful.
Okay. If we are to categorize Australia, I would say that Australia adopts a jus sanguinis rule. And that's because by general rule, you do not acquire the Australian citizenship just by being born in the territory of Australia. There are always some qualifications imposed on those who are born in Australia for them to acquire the Australian citizenship. So, pure and simple, just by the fact that you were born in Australia does not grant you, does not entitle you to become an Australian national. So let's go to the rules and let's see the exceptions. You will have the Australian nationality if 1. You are born in Australia and you are the son or the daughter of an Australian citizen or permanent resident in Australia. The mix of jus soli and jus sanguinis is applicable in the first rule, because if you are born in Australia, according to jus soli, and if you are the son or daughter of an Australian citizen or someone who has a permanent residency in Australia, jus sanguinis, then you acquire the nationality by descent. The second rule is that you can become an Australian citizen only by birth, by being born in Australia without having Australian citizens as parents or permanent residents, as long as you continuously reside in the Commonwealth for at least 10 years. So this is a qualified application of the jus soli rule. You see, it's possible for someone who was born in Australia but doesn't have the bloodline of Australian citizens to actually become an Australian national. If that person is born in Australia and continues to reside in Australia for at least 10 years, then that person can regain the nationality. These two rules are provisioned in Section 12(1) of the Australian Citizenship Act of 2007. The third rule is a pure version of jus sanguinis in Australia. A person who is born outside of Australia but is the descendant of an Australian citizen will gain the Australian nationality by descent. According to Section 16 of the Australian Citizenship Act, a person born outside Australia on or after 26 January 1949 is eligible to become an Australian citizen if a parent of the person was an Australian citizen at the time of the birth. Now, there are some other qualifications on some other types of nationality acquisition. For example, nationality can be acquired by adoption if the person is adopted by Australian citizens. It can also happen by the incorporation of foreign territories, or even if the person was abandoned and found in the Australian territory. And it is also possible for individuals to become Australians by conferral. To do that, you will need to comply with certain requisites and also be approved by the relevant minister. These rules are laid out in Section 19G of the Australian Citizenship Act. All in all, in Australia we have a mix of jus soli and jus sanguinis, with a predominance of the jus sanguinis rule. Well, I hope you enjoyed learning more about the acquisition of nationality and citizenship in Australia. Make sure you are subscribed to our channel and that you like this video. And I hope to see you next time. Until then, ciao.